Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about what benefits or why you don't really need to hire a local immigration attorney, and why you are able to hire an expert immigration attorney who might be thousands of miles from you, and how that will better affect your case ultimately in the end. In this particular regard, you can actually look at several different factors as to why it would be beneficial. Now, let me explain to you a little bit about how the practice of law works and how one is able to practice in different jurisdictions. Now, normally, if you're talking about a state law, and we're talking here mostly real estate, personal injury, criminal law, civil law. There's tons of state laws that are different in every state that you go. For example, you say, how do you do a divorce? Well, if you're in California, it's going to be different than if you're in Kentucky, and that's going to be different than if you're in New York. It's different all over the place. So that's a state law, and what that means is that you cannot, if you are licensed, for example, in California, you cannot practice in Kentucky, okay, for family law, because it's state. You need to be licensed in that particular state. If you want to practice, for example, in Texas and Florida and California, then you need to be licensed and pass the bar in California, Texas, and Florida. Okay, so that's how that works. Now, why is immigration law different? Well, immigration law is federal law. It is controlled by federal statutes, federal regulations, federal policy. There is no state immigration law. You can't go, for example, to Oregon and say, okay, I'd like to petition my mom. What are the immigration laws of Oregon in order to do that? Or you can't, be in deportation or removal proceedings in Florida and say, okay, now what are the removal proceeding statutes in Florida? No, it's all federal law. Now, because of that, that means that someone like me, who passed the bar in California, I can practice anywhere in the United States. It doesn't matter whether you have a case in New York, in Texas, in Washington. It doesn't matter whether you're being deported from Kentucky, from Kansas. None of that matters. What matters is that because immigration law is federal law, as long as you are licensed in one particular state and you are an attorney, then you are able to practice in all of the states. Now, given that, that means that I can help somebody, a client, from wherever they happen to be. I happen to get calls all over the United States. I give consultations, and generally, a lot of times the conversation starts off, well, you're in California, how can you help me here in Montana? Well, the fact of the matter is that I can. First of all, the way my system is set up is we have a web portal, okay? And once you sign up with my firm, the web portal allows you to log on 24/7 to upload documents, to see what the document list request is, to answer various questionnaires, to see various custom questionnaires, to communicate with myself, one of my other attorneys, the case manager. I mean, honestly, you could be in China at 1 a.m. and still have access to your entire file and everything that needs to be done in regards to the file. So, strategically speaking, just computer-wise, it's not a problem. Because everything is on the internet these days anyway. So if you can access everything while on the internet and send questions and so forth, then it doesn't really matter that you happen to be in a different state. So then the question becomes, which I've spoken of before this, are you able to take a case, or are you able to give an attorney who's an expert immigration attorney a case where he's not local to where you live? And again, legally speaking, the answer is yes, because immigration law is federal law. Now, given that, does that mean that the application of immigration law is the same no matter where you are? And the answer to that is no. Okay? The answer to that is it depends on the jurisdiction you are in, and it depends how it's applied. So then the question becomes, well, if myself, for example, an attorney from California can practice, represent a client in Texas, let's say in removal proceedings, why is the law different if immigration law is federal law? Well, let me explain. First of all, there's lots of different sources for immigration law. And we are a nation of laws and regulations. So the question is, what types of laws exist in the different jurisdictions? Well, of course, there's all the immigration nationality cases, and when one, for example, loses in the immigration court, it goes up to the Board of Immigration Appeals. There is one Board of Immigration Appeals in the whole United States. It's in Virginia, and they make law. They issue many precedent decisions, which means that if they issue a decision, that is the law at that point. Now, what happens if somebody wants to appeal the decision from the Board of Immigration Appeals? And vice versa, or likewise, if, for example, someone applies for a non-immigrant visa, they don't have to be in removal proceedings, and it goes up to the Administrative Appeals Office, or the AAO, and they lose there, then it can also be appealed. So the question is, what happens when it gets appealed outside the forum of the administrative law? And what happens, I'll just take the BIA, the Board of Immigration Appeals example. Let's say that you lose at the Board of Immigration Appeals, and you appeal up to the Circuit Courts of Appeal. Now, let me just give you a little idea of how this works. You take the United States, and let's say you divide it into 11 or 12 slices. Okay, that's really how it works. And of course, we're including Hawaii, Alaska, all that. And depending on what slice you happen to be in, and we're talking vertical slices more or less, what slice you happen to be in, that is the jurisdiction of the Circuit Courts of Appeal. So for example, California, you're in the 9th Circuit Courts of Appeal. In Texas, you're in the 5th Circuit Courts of Appeal. And as you go more and more east, you get different Circuit Courts of Appeal. And then, Washington, D.C. has its own Circuit Court. So basically, what happens is you appeal something from the Board of Immigration Appeals, it goes up to a Circuit Court of Appeal. Now, the 5th Circuit does not have to follow what the 9th Circuit does. Meaning, if you're in Texas and you've appealed up, and let's say you're appealing some decision. I'll just give you an example. Let's say you filed an asylum case, and you're from China, and let's say that you say, and let's say you're female, and let's say that if you go back to China, they're going to force you to do forced sterilization. Okay, because you already have a child. And let's say you're appealing up, you lost at the Board of Immigration Appeals, you lost at the Immigration Court, and it goes up to and let's say you're in Texas, it goes up to the 5th Circuit Court of Appeal, and you're appealing that you should be granted asylum because you're going to have forced sterilization put upon you when you return to China. Well, let's say that the 9th Circuit already has a decision that says, yes, forced sterilization in certain circumstances will qualify an applicant for asylum. But while the 5th Circuit can look at that decision, they cannot, they're not bound by it, okay? And they can make their own decision. And in fact, they can rule exactly opposite of what the 9th Circuit does. They can say, that forced sterilization is not a ground for asylum. They can say that they disagree with it, they don't like it, they think it's barbaric, whatever it is they want to say, but they might ultimately rule that it doesn't fall under the grounds of asylum, doesn't fall under persecution definitions, completely opposite to what the Ninth Circuit might say. And so that's how the laws differ depending where you are. Now, how does that affect, for example, a lawyer like myself in California if I'm going to Texas to fight a case? Well, obviously as an attorney, we have learned how to research. We have learned how to determine what the laws are in particular jurisdictions. And so in this case, again, you ask yourself, does it matter, or would it be better to get someone who's local, who may not be an expert in immigration law just because they're local? And the answer is no, it wouldn't be better, because the key here, and I'll just go on this example, and you could use 1,000 different examples, but I'm just going on this one to clarify the point. In this case, let's say you're in the removal proceedings and you want to do a petition for review, which is basically an appeal to the circuit court. In this case, the question is not whether the law is different in the Fifth Circuit versus the Ninth Circuit, but does the attorney know asylum? Does the attorney know how to make arguments for asylum against the items that hurt you? Is the brief and the opening brief and the procedures for doing petitions for review available to that particular attorney? So the question is, yes. I mean, if I am an expert in asylum law and I know how all of the elements work, then yes, the fact that the Fifth Circuit is different than the Ninth Circuit, that's fine. That's what we do as lawyers. We argue why the case should be won, why we believe that it's persecution. Obviously, in the Ninth Circuit, let's say, I'm just using this example, let's say that they've already ruled that forced sterilization qualifies an applicant for asylum. Well, then my job's easier, because then I don't have to specifically argue that it should. I can pull up that case, show how it's more or less the same, and then argue from there that this is similar and therefore should be granted. But with the Fifth Circuit, if they don't have such a decision, then I can pull in the Ninth Circuit case to argue that it's persuasive authority, that they should follow it, and this is the reasons why. And so let me tell you where it goes from the circuit courts of appeal, because as you can see, the different circuits will have different decisions, and sometimes completely opposite, and sometimes in between. So, again, if we're doing the forced sterilization example, and you go through all the circuits in the United States, and let's say you have 3 of them that have no decision, you have 4 of them that are for, and 5 of them that are against, and it's all over the board depending where you are. Well, see, now this would be a good case to do what's called a writ of certiorari all the way up to the U.S. Supreme Court, because this is the type of stuff that they will look at. They will look at important constitutional related issues that are in disagreement all over the United States, and where they need to put some uniformity in there. So, of course, this takes years. It takes a long time to get up to that point. But if it does go up ultimately to the U.S. Supreme Court with differing decisions, then they issue a particular decision that will unify the theories on it and so forth, and then we go from there. And just so you know, many times it's still not even that clean when it's issued by the U.S. Supreme Court, because there's always caveats, there's always situations that it applies to, it doesn't apply to. There's always arguments that your particular case falls under it or doesn't fall under it, so there's different ways of going about it. But that's how it works. Now, let's talk about just strategically. You have a case in a different state, let's say, than where, for example, where I happen to be located. But let's say it's a case that deals with waivers and deals with consulate processing. Well, it's not going to matter that let's say you live in Missouri, that you happen to have a lawyer down the street. If that lawyer has never done a waiver of the 10-year bar, or a fraud waiver, consulate processing, or permission to re-enter, how's that going to help you? Because the fact is that let's say you come from Mexico. A lot of the documentation and petitions are going to be sent to the U.S. consulate in Ciudad Juarez. So it doesn't matter that, I happen to be in a different state. You have the waiver, it has to be shown, the hardship, and you have to have all the supporting documentation and the procedures in line in order to get it approved. So that's how it works. Now, in regards to things that go to different service centers, jurisdictionally speaking, there's different service centers over the U.S., in California and Texas and so forth, depending where, in Vermont, depending where you happen to live. And there's different petitions that go to different service centers regardless of where you live. For example, let's say you're a battered and abused spouse, and you're doing a VAWA petition. That's going to go to Vermont. Doesn't matter if you live in Vermont, doesn't matter if you live in Hawaii or New Mexico, it's going to Vermont. So, in regards to that, you can see that procedurally, it doesn't really matter where the attorney is. You need to look at the background, the experience, and the qualification of the attorney so that you make the right decision. Now, a lot of people, they don't feel comfortable hiring an attorney unless they see them. Well, let me just tell you how I deal with that. If they don't feel comfortable unless they see me, a couple things. One, I can actually be retained to fly out to you and meet you there or the other way around. Or what I do even more often is I have Skype consultations. And the way Skype works, it's great. You get on, you put the camera on your computer, and boom, there you have the in-person sort of meeting. So, you can do your research, you can look around, but hopefully I've explained to some reasonable degree what is involved with practicing immigration law in different states other than where one happens to be physically located. Keep in mind, immigration law is full of potholes and bureaucracy, and if you get someone who doesn't really know what they're doing and they do one petition for you, but they don't see how it affects other parts, 3 years down the line, you might get a denial and be put in deportation because of it. Things that could have all been done differently in the beginning. So, do your research, look around, and if you would like a consultation, give me a call. If you have questions on this issue, also let me know, and I'll be happy to help. Okay, more in the coming videos.